Hello, I'm Andy Agavangelo. I'm very proud to be the founder of a certified social enterprise that's based in the UK, but our community stretches into 20 countries around the world. There's roughly 5,000 people who get our weekly newsletter called the Transparency Times. The Transparency Task Force is an organization I created in 2015. It's a not-for-profit. It functions as a campaign group. We're all about the idea that the financial sector is profoundly important to the well-being of society, to political stability, to economic stability. But we also believe, and I certainly know this from my own career history, we also believe that given the chance, the financial sector will find a way to shortchange people, rip people off, exploit them rather than serve them. And therefore, what we want in the Transparency Task Force is a regulatory framework that makes the financial sector behave the way it ought to. And speaking very frankly, if I think about the UK's primary conduct regulator is the Financial Conduct Authority. And please believe me when I tell you, I've learned hundreds, if not thousands, of reasons why the UK's primary conduct regulator is not nearly as effective as it should be. You might think of it as being captured. You might think of it as being conflicted or complacent. You might think that the banks have got far too much influence over it. There's a long list of reasons that might explain why the UK's FCA doesn't do a particularly good job. And when I speak to my many newfound Irish friends, we have really similar conversations about the Central Bank of Ireland, particularly in relation to banking misconduct, particularly in relation to this foreclosure fraud, as David Dayen describes it so beautifully. And it's interesting because just earlier today, I had what must have been my, I don't know, 10th conversation with people about how the SEC in the US, the Securities and Exchange Commission, is less conflicted than our regulators in Ireland and the UK. Less conflicted, perhaps, because it's got a more focused perspective on the interest. And it's interesting because I just noticed a really cute smile from David Dayen when I mentioned this idea of the SEC perhaps being a better regulator. I'm sure it's not perfect, but believe you me, David, in the UK, we can give our regulators hard evidence of misconduct, literally hard evidence of misconduct, and the regulator won't even act for maybe a couple of years. There's a BBC Panorama documentary I'll refer to later on about that. Enough from me, other than to say, welcome everybody, particularly those of you who are brand new to the Transparency Task Force. Can I please invite everybody now to put their hands together, not just to thank David for writing his book and for taking time to be with us. He's a very, very busy man. I've found out quite a bit about him over the last few weeks. He's a very busy man, very focused gentleman. We're really privileged to have him with us today. Can we thank David not just for his book and for being here, but probably the most important thing, for having the kind of mindset that cares. That's actually the bit that really matters, a mindset that cares, because people who are capable, who care, achieve great things. And David's clearly done that, not just through his book, but through many other things as well. We'll go to David. We're really looking forward to hearing what he's about to say. Please put your hands together to thank Mr. David Dayen for being with us tonight, folks. Thank you very much indeed. David, when you're ready, sir, take yourself off mute and share with us what you'd like in whatever way you'd like to do that. And then we'll have a bit of a Q&A after that, and then we'll go to Nigel Keynes to talk about his first impressions of your book. Over to you, sir. Thank you very much.
Well, terrific. Thank you so much, Andy, for that very warm introduction. Very nice of you to say those kind words. I am a journalist. I am actually the executive editor of a magazine called The American Prospect, based here in the US. And in 2016, in the aftermath of the Great Recession, which was a terribly scarring event for the United States, something that led to, the crazy thing is that our government doesn't actually count how many foreclosures are conducted on an annual basis, but by best estimates, 10 million families were separated from their homes in the aftermath of the Great Recession. And in 2016, I wrote this book called Chain of Title, and it told what was at that time a relatively untold story about the circumstances leading up to this terrible crisis, the activities and practices by the major banks and mortgage servicing companies and trustees in the United States that put these foreclosures through a very broken system. And the really inspiring story, I mean, Andy, you referred to me as the one who cares, but I really think it's, what I did in this book is told the story of three people who cared very much because they were victims of foreclosure, who decided to do this, they committed this revolutionary act. They read their own documents, and within those documents, they found the seeds of a great crime that was committed, a systematic crime that was committed over and over again in the nation's courts. It amounted to a complete demolition of the home recording system, the title recording system that had lasted in the United States. It actually predates our US Constitution by 150 years. The first recording system was put in place in the 1630s in the United States, and it worked fairly well for close to 400 years after that, until a group of unelected bankers took it upon themselves to change that system for their own benefit, for their own purposes, basically to save money and to enable the mass of trading of mortgages, turning mortgages into a tradable instrument that occurred and facilitated the housing bubble in the United States, which of course popped so spectacularly at the 2006, 2007, 2008. And so what really drew me to the story was that these were people who were not knowledgeable about the financial industry. They were not activists in any way. They were an oncologist nurse, an auto dealer representative, and a lawyer, but a lawyer that was involved in insurance, an expert witness in insurance fraud cases. So they didn't have really any connection to the business of home mortgages. What brought them together was the circumstances in Florida, which was really ground zero for the foreclosure crisis in the United States, by which they were in different ways put into this position of having their home dispossessed. And at that point, they decided to look deeper into not only the causes of the crisis, but the means by which these homes were being taken away from people. And what they learned is that the system as it worked in the United States was that mortgages were issued by a series of originators, some of them banks, some of them non-banks, and immediately sold either to Fannie Mae and Freddie Mac, which are sort of government-sponsored quasi-public, quasi-private enterprises, or into the hands of private securitization, which was managed through a very complex series of transactions with trustee banks and essentially investors from all over the country and actually all over the world were able to purchase slivers of this pool of mortgages that were put together. And so, a pension fund in Norway or a teacher's fund in Indiana in the United States could then buy a piece of these mortgages and then get paid out based on the stream of payments monthly that were made by mortgage borrowers all over the country. And in order to do this at industrial scale, in order to do this in the way that could facilitate millions of these transactions, as I said, they had to break this system of recordation. They didn't want to pay money to a recording office, a small amount of money but in the big picture, if you do tens and thousands and millions of transactions, actually a large amount of money. They didn't want to pay the recording office every time they transferred a mortgage. And so they created a private database, a system whereby they could make these trades by themselves without informing the individual recording companies, which are recording firms. These are public entities. They're usually done at the county level here in the U.S. So they created this sort of privatization of the system of mortgage recording. And the problem is that in their rush to do so, they did not follow the proper steps that were laid out in very specific documents, pooling and servicing agreements that were documented and laid out under New York trust law. And they didn't follow these steps because they didn't think they had to, really. I mean, they wanted to save money. They wanted to continue to trade these mortgages as quickly as they could. And they believed that as long as the mortgage industry remained robust, as long as people could refinance their way out of trouble, as long as not a bunch of mortgages all failed at the same time, which they thought at the time was impossible, that they would be safe, they would be okay, nobody would ever find out. The problem is, of course, that there was a collapse of the housing bubble in the US and also around the world, and in many places, including Ireland, that meant that these losses were correlated in a way that was unexpected, that suddenly it wasn't just one part of your portfolio, of your pool of mortgages that was failing, but many of those mortgages from all over the country. And when that happened, what the banks realized is that they actually didn't have the proper documentation to prove that they owned the mortgage, because it had traded hands so many times, and it was in the name of this trustee, which didn't follow its own practices, that they had a real problem on their hands. They could not legally explain who owned the mortgage in a court of law, which in many states, including Florida, is the way in which you need to foreclose on somebody. We have two different processes for foreclosure in the United States. About half the states are judicial foreclosure states, where you actually have to get a judge's order to foreclose. And then another half are non-judicial, where it's just a trustee note and it's a separate process. But Florida, which was one of the biggest states, and first of all, it's the third largest state in the country, but also it was the largest state that had a major meltdown like this in their mortgage market. You needed a court and you needed documentation to say, I actually own this mortgage, and therefore I have the right to foreclose on this borrower. And so, lacking that documentation, it was fabricated, and it was fabricated on a mass scale. There were document fabrication offices that were put in place throughout the country and also even overseas that would create notes, create mortgage assignments, backdate these notes, falsely sign these notes, have them rushed through, signed by these people making $10, $12 an hour, who were signing their names, given seals for to be bank vice presidents, the most productive bank vice presidents in history, because they were signing tens of thousands, hundreds of thousands of documents. This one woman named Linda Green was made into a bank vice president, and 12 people in her office were signing her name on these bank documents. And they the company, this company called DocX, this fabrication shop, was asked, why did you use Linda Green on all these documents? And they said, well, her name is easy to spell. And so it was easy for her to be used by those $12 an hour workers to just sign their name. And we have these documents in the public record with her handwriting in 12 different forms in the public records, claiming that these are all Linda Green, who is signing off saying that these are in fact official documents. And so my three protagonists, Lisa Epstein, Lynn Simoniak, and Michael Redman, start uncovering this information, and they start figuring out that a lot of these cases are based on false documents. Lisa Epstein, who I follow near the beginning of the book, really becomes obsessed with going through the public records. And she worked as an oncology nurse at a hospital in Palm Beach, Florida. And it was about half a mile or so from the public records office in Palm Beach County, Florida. And on her lunch break, she would walk 15 miles, maybe 10 miles if she could run to the public records office, look through the documents, and then go back to her job. This was every lunch hour for months and months on end. She spent so much time at the public records office that she started to get mail there. She got mail from other foreclosure victims who were looking for advice, looking for information on how they could fight their own foreclosures. And she became something of an advisor to these various people that didn't know what was going on. It was a situation where in the US, these kinds of matters, especially around foreclosure, there's a lot of shame attached to them. Lisa referred to it as how people would call cancer the big C. It wasn't something talked about in polite company. You didn't want to know that your neighbor was being foreclosed upon, and maybe that would affect your property values. And so there was this conspiracy of silence, really, around what was being perpetrated by the banks because people didn't get together. And what Lisa and eventually, after she met Michael Redman and Lynn Simoniak, did was they created this community. And they created this community around a group of websites that they started, which had comment sections. And they met each other in the comment sections of other websites that predated them. They sort of figured out this information throughout these comment sections, and they would share notes and compare notes, and then they started to do public meetups in Palm Beach County. They would have a foreclosure fraud happy hour every month, where they would share information and documentation, get involved with lawyers who were fighting, foreclosure defense lawyers who were fighting these cases in Florida. And they were very dedicated to trying to get this information into the hands of people who should do something about it. So whether that was the Florida Attorney General's office, whether that was the federal regulators, Lisa Epstein had a system where she would write a note to 5 regulators every single day for months on end, just begging anybody to pay attention to this. And eventually they did start to get a few people interested. They got some foreclosure defense attorneys who would use their theories in cases. They even got some judges to agree to that and block foreclosures that were being submitted with false documents. Really a criminal activity, if you think about it, using false evidence to convict somebody. And they even got some regulators to take a look and start investigating aspects of the system, whether it was the trustee banks who were fabricating these documents, or the what they called the foreclosure mill law firms that were churning out foreclosures, like a sawmill churns out lumber. And so eventually what happened through all of this organizing and agitating and activism is, at the end of 2010, around October 2010, the major banks in the United States all paused their foreclosure actions because they realized they couldn't do it anymore legally. The trigger for this was something called the robo-signing scandal, where as I mentioned, these documents would be robotically signed over and over again by minimum wage workers who had no connection to the banks for whom they were signing. And so at the end of 2010, there really is this break where these three ordinary Americans who just did what everything in our civics textbooks tell us is the way to make change. They organized and they activated and they got the truth out. They really made a difference in pausing all of the foreclosures in the United States at that time. And that's a really inspiring story. And that's about 2/3 of the way into my book. And if you close the book, it's a really inspiring story. Unfortunately, I have to tell the story in the final third of the book where no meaningful sanction is ever laid down upon the bank executives who actually perpetrated this set of systematic crimes. Ultimately, there were settlements that were not terribly meaningful either, not terribly meaningful on banks and the financial companies who simply saw them as a cost of doing business, and not terribly meaningful for families who continued to be foreclosed upon and got very little relief out of those settlements. The reason I wrote this book was I just thought that it was so important to preserve this history. The book came out about 6 years after that fulcrum point that I mentioned in 2010, where all the foreclosures in the country stopped, and there just wasn't much attention into why that happened and why there was nothing ever really done about it. Why the accountability had never come forward. And as I describe it at the beginning of the book, it left this sort of gaping hole at the heart of U.S. democracy in my mind. It created this sense of inequity in the system, a two-tiered system of justice where what you did mattered less than who you were, and it created this just alienation and anger, something that we've seen obviously in future years. This book came out in 2016, and we know in 2016 the United States elected Donald Trump to be the president of the United States, and some of the people who I talked to for this book believe that those two things are coordinated. That those two things, there's an action and reaction available there. So I just wanted to keep this history alive and make sure that people knew that we actually had a moment where we could have held banks who crashed our economy and then tried to cover up the crime through another series of crimes, could have been held accountable, and they weren't. And it was for me a dark warning for the future, because we know that at some point this is going to happen again. And as you're telling me, Andy and the others here, it is happening again in other countries in the world. And I can't say that that's terribly surprising, given the example that was set here in the United States. Even to this day, the recording for homes and mortgages remains unreformed largely. Securitization, private label securitization, has really gone out of style in the U.S. There are fewer and fewer mortgages that are privately securitized in the way that created all these problems. We still have Fannie and Freddie, but the vintage mortgages, the legacy mortgages, are still these time bombs that are in recording offices all over the United States. And we should know that, and we should work to change that, and we should work to make sure that these kinds of things don't happen again. So that's why I wrote the book, and I really appreciate your interest in it all these years since. We're talking 7 years later, and I'm happy to take any questions you might have.
David, you've provided us a wonderful, wonderful overview of your motivations for writing the book, the three folk that you've made reference to. We'll come back to them later. And you've also said enough for me to absolutely know, David, that what the folks in the US have experienced is mirrored, absolutely mirrored in Ireland and in the UK. I'm absolutely sure of that. It's almost as if we're all familiar with the phrase, sharing best practice. This is like the opposite of that, sharing evil practice, sharing nasty practice, sharing horrible practice, sharing egregious practice. It's almost as if they go to school to learn how to do it and how to internationalize this stuff. We've got Mr. Steve Middleton, who's one of our speakers later. His hand went up first. Mr. Middleton, to you, sir. Thank you very much.
David, first of all, that was fascinating. Thank you very much. So my copy of the book only arrived today. I'm very much looking forward to reading it. Do expect some emails from me in about a week's time with numerous questions about what you did find. What is quite fascinating there, and maybe should be the subject of another book if you're thinking about writing something further on this. You seem to have the same problem in the US as we certainly have here, where bankers are a protected species. So we have a situation in England where we have 43 police forces, 42 of whom report to the Home Secretary. The 43rd reports to the City of London Corporation, which is a city, as you're probably aware of, run in the square mile in London, and very much controlled by the banks, magic circle firms, law firms, and accountants who work in that area. They control every aspect of analysing, investigating, or prosecuting white-collar fraud in the UK. And on that basis, in I think the last something like 10 years, only 4% of fraud has been investigated in the UK. So we very much have a captured legal system here, where effectively the law is the law and the regulations are the regulations, but the banks are telling the judiciary what to do, and the banks and the regulations and the law going out the window. Is it the same over there, do you think?
I mean, to a degree, certainly. I mean, certainly that was the case with respect to the criminal and civil enforcement with respect in the Justice Department in the aftermath of this under the Obama administration. We had a situation where Eric Holder, who was the Attorney General of the United States, was previously a lawyer for Covington and Burling, which is the corporate defense firm that represents all of the major banks. And so Holder was negotiating these settlements with these major banks. And at the same time, Covington and Burling, who were the representatives of the banks who were doing these negotiations with Eric Holder, they were also holding open a corner office for Eric Holder for when he left the Attorney General spot. And indeed, when he did leave, he went right back to Covington and Burling and went into that corner office. It's an absolute scandal that you almost never hear about in the United States. And so we see those kinds of things repeated here and there. The Biden administration has been a little bit better on these issues as it relates to certain aspects of corporate power. With respect to the banks, we are putting in forward what is known as the Basel III endgame, which is the expansion of capital requirements above and beyond what they have now in place. And the banks are going absolutely apoplectic about this. And the one thing that I don't know to the extent to which this is true in the UK, but the allies for the banks on this are actually civil rights organizations who are often paid by banks with large sums of contributions, and then go out and say, if you raise capital requirements for the biggest banks, then it will restrict access to credit for the poorest and most vulnerable people, including people of color in the US. And it's a sort of insidious relationship that the large banks and these civil rights groups share, even though the terms by which they make these statements are preposterous. Currently in the US, the vast majority of mortgages are sold through non-banks. who would be completely unaffected by this change in capital requirements. In addition, some of the biggest scandals, including one very recently with the nation's largest credit union, in terms of racial discrimination, lending discrimination, would also be completely unaffected by this change in capital standards. So I feel like the that sort of relationship between so-called civil rights organizations and the big banks remain. I feel like we're seeing a little more independence on the part of our regulatory apparatus. Whether you're talking about the SEC, which has done a good job in some respects under the leadership of Gary Gensler, or you're talking about we in the aftermath of the Great Recession, we put forward this thing called the Consumer Financial Protection Bureau, which is now under the leadership of a really fine individual named Rohit Chopra. That organization has gone a long way to making sure that consumers aren't tricked and trapped by mortgages in the U.S. since the Great Recession. So, we've had some successes. There are also plenty of failures, particularly on the enforcement side. But I'm interested to hear more as we continue this conversation about what the state of things is in the UK.
Thank you so much, Steve, for the question. And thank you, Dave, for your response to it. We're going to go to Nicholas Wilson. Folks, most of you won't know Nicholas because we have a lot of brand new guests here tonight. I won't spend time explaining this, but I will say Nicholas is one of the most inspiring whistleblowers and anti-corruption campaigners you're ever going to have the pleasure and the privilege to talk to or listen to. He really is remarkable. Please, I'll put some information about Nicholas in the chat shortly, but in the meantime, let's go to Nicholas, who's probably going to tell me off again for being so nice with my words.
You're always too kind to me. I can't live up to it. Actually, David, thank you for that. It was very interesting. I don't really have a question. I just want to point out that people who do know me might notice a difference in my background here. This is real time what is going on with what we're talking about. My mortgage has gone up 14 times in the last 18 months to the point where I can no longer pay it. I have no idea who owns it. It's got a trustee. The title is owned by a trustee, which is part of Computer Share, which everybody will know about. But the beneficial owner, I have no idea. So it got to the stage where I simply can't afford to pay it anymore. I've sold my house and I'm moving out to a flat. It's actually, I'm much better off than many people because I did have some equity, and it turns out because I'm buying a short lease on a flat, I can live mortgage free. So it's turned out well, but I will miss this beautiful house which has got a garden. The flat doesn't have a garden, and the worst thing I found out this week, I have to give away my cat because I can't take my cat to my flat. And I mean, there's a tiny thing in the scheme of things, but these bastards who are doing all this with our mortgages, they have no idea of the human cost. Suicides, it goes all the way up to the human cost of it. So I just pointing it out. Thank you for listening.
Well, thank you for telling your story. I mean, absolutely, there is this huge emotional component to the whole concept of home ownership. I mean, when you hear stories in this country about the American dream, the white picket fence and the home of your own is intimately tied to that. And when I talk to people that were in the situation like you, Nicholas, I talked to dozens, if not hundreds, of folks who were experiencing this stress and problem with their mortgages. They would tell me that they would the lengths to which they would go to keep their mortgage payment because that home meant something to them is just astounding. They would forego food. They would forego medical care to keep that mortgage payment going. That was so emotionally and viscerally important to them. Yeah. And the mortgage companies in some way play off that. They know that you're you're going to pay that mortgage above everything else. And so we can raise it and we can lock you in and we can trap you. And we're not going to face any consequences for it. And so, you know, I really resonate with that story that you're talking about, because I heard it from so many people.
Thank you, David. Thank you very much indeed. We're going to go now to Mr. Nigel Cairns, who's going to talk briefly, just very, very briefly, about his first impressions of your book. I'm emphasizing the first impressions for a reason. So allow me to explain why Nigel can only talk about the first impressions of your book, because here's Nigel's copy of your book. And the reason I've got Nigel's copy of your book, sir, is because Edmund Honohan, the Master of the High Court in Ireland, wanted to show your book, Mr. Dayan, at the Finance Committee meeting that took place last week, a profoundly brilliant session that was televised. I'll come back to that in a minute. And Mr. Nigel Cairns, knowing that I wanted to get a book to Mr. Edmund Honohan very, very quickly, when there was no way of being able to post it, and knowing I was going to be travelling to Ireland to go to the meeting, Mr. Nigel Cairns drove 3 hours Sunday before last to get this book to me, and I'm forever grateful for that. So that's Mr. Nigel Cairns, and that's why he's not had a chance to finish your book. So having said that, can we please now invite Mr. Nigel Cairns to speak briefly about his first impressions of your book? Nigel, thank you very much.
Good evening, David, and everybody else. And yes, I did agree that I'd say a few words about David's book, but it was on condition I got the book back before I was actually going to give this this talk, which, as you can see, hasn't quite happened. Just as a sort of preliminary, I'll explain my comments in the context of somebody that's for nearly upwards of 10 years been threatened by a major high street UK bank with foreclosure. And in my case, they did actually foreclose and then or started requested repayment, and then proceeded over a number of years just to threaten me with the continuation of this process unless I jumped through all the hoops that were demanded of me, such as paying additional fees, an increased rate of interest, etc., which is a familiar story, I now know, with many other people. But I didn't know that for a number of years, and it was particularly difficult, especially in the early years, thinking I was all alone, which again is a common theme. So that's where I'm coming from in explaining my interest and why I was very keen to get your book as soon as possible, because I think in my case, and possibly many others, the details that are held at the UK Land Registry, I think are false details even to this day. And it's something that you know, I'm hoping to continue to pursue. So, you know, in common with many others here, we're interested to learn more. David, in your introduction earlier, you've covered off nearly all the points that I wrote down that I was going to mention, so I'm left with very little to say. But there are still a few points that I'd like to make. And I suppose I started off when I was asked to say a few words in thinking what caused you to write this book in the first place. And even the limited amount of reading that I have done, it was quite clear to me that you were using the book as a vehicle to get to a much wider audience. You obviously felt the need to get the story out there to a much wider audience than otherwise would be the case for sort of a more esoteric audience that would just look in the financial papers of newspapers, or, you know, the narrow court cases and things like that. What we're talking about is a very widespread and a very human story of misery and tragedy in just so many cases. And where the book really succeeds is that you you look through the window of people's lives in how it affected them. These happen to be Americans, and you get a flavour of, you know, the detail of their lives, which, you know, brings the whole story to life and make sure that it means a lot more to the reader than just reading the dry facts. And I think you've achieved, if that was your objective, you've achieved it magnificently.
Wonderful.
And we, quite honestly, we wouldn't all be here tonight if your book had failed. It's obviously succeeded, though perhaps not in the way that you could possibly have envisaged when you were writing it. You know, to now transcend at least three different countries. I think what came across to me was the empowering ability that the three people that you refer to in the book, the subject matter of the book, the empowerment that they got in their belief and determination to resolve the injustices that they'd gone through, not just for themselves, but, you know, on a wider basis. And you've provided through your book, you know, the perfect way to carry that through, which is a magnificent achievement, and I'm very grateful to you for that. And the other point that I wanted to get across, which has already been alluded to, is the accountability of the bankers and the regulators and the people that have the responsibility and the powers to control the matters that could and still can prevent the very widespread and unjust misery caused by, you know, the bag of tricks that the lawyers come up with to basically steal money on behalf of the bankers. In this country, the politicians like to describe the bankers as being very talented. And this is the full, in my opinion, this is the full extent of their talent, in that they're very good thieves, but it doesn't get much beyond that. So the message that I'm hoping will develop from the book and from everybody's involvement is that accountability, or supposed accountability, should not come without consequences of wrongdoing for those people that are held accountable. A huge problem that we seem to have is that people are accountable, but all we ever get is lessons learned, or we'll, you know, taking this into account when we rejig the legislation, you know, the next time it comes round. But nobody ever pays any consequences. And until that feature is properly addressed, I think we're all going to struggle to actually make a decent headway to stop the ongoing misery that everybody's suffering. But this is, you know, we're on the perfect path to do something about this through the meetings and through the books, yours as well as a recent book that's come out in this country called Rigged, which hopefully you've heard something about, do precisely the same job. They're getting their message out there in a form that's getting political interest as well, which is hugely important to us all. So I'll shut up there because Andy does like people to be succinct, and I probably haven't been. But anyway, thank you very much for allowing me to say a few words.
Well, whether you've been succinct or not, Nigel, is a matter of debate. But what's not a matter of debate is your heartfelt narrative. This is a book that matters to you, a book you can identify with, and a book that many people in this conversation can relate to. The simple reality is, I've got some background noise. I'll try to deal with that in just a second. Tony, please keep yourself on mute. When people booked onto the session today, they actually were invited to comment as to what was their main sort of motivation for being here. And I'm so sad to tell you that David, that basically there are many people here today in this conversation because they are quite literally in the process of having their homes foreclosed. It's off the scale sad. It really, really is. In a moment, we're going to hear from Seamus May after I've said a few other words. But before we do, can I please invite everybody to once again show their appreciation to David Dane and, in fact, Nigel as well for sharing his thoughts as well just now. Thank you very much indeed, David. Please stay with us. I really do hope you find what you're about to hear from the Irish perspective and the UK perspective of interest. And if you don't mind, David, when we come to the end of the event, I'll invite you to share some final words, if that's okay with you. Okay, thank you.
Sure.
Thank you very, very much indeed. Folks, I'm gonna share something with you. I'm going to share my screen, and I'm going to show you something I'm going to encourage you all to do, which is this. I'm going to put this link to this web page in the chat, and I'll put a link in the chat in a minute. This is the web page of Ireland's Finance Committee. The UK has something very similar called the Treasury Committee. Here's Ireland's Finance Committee. I was privileged to be invited by Edmund Honohan, the Master of the Court, to attend his session the other week. It was on Wednesday, the 13th of December, that's just last week. And I was able to sit in the public gallery and I was able to observe a master performing masterfully. And when you get to this webpage, and I really do encourage you to do it, click on the bit about that particular event, then click on this bit here where you can read the actual write-up of the event, you know, the word-for-word account of who said what. The session was run by this gentleman here, John McGuinness, TD, that means he's a politician, TD, a wonderful man. TTF has got to know his work quite well over the last roughly 6 months or so. He consistently speaks up on behalf of the people against the bankers, which is wonderful because it's a very David and Goliath battle. There's a particular part of this session that I'm going to read out because it chimes with our American guest today for reasons that will become clear. It's the part where Edmund reads out a quote from the former chairman of the US Securities and Exchange Commission. So this is Edmund Honohan, who said the words I'm about to read out. Okay, Mr. Edmund Honohan, the Master of the Court. He said, I have a quote from a former chairman of the US Securities and Exchange Commission. In his book, Take on the Streets, he wrote, during my 7.5 years in Washington, nothing astonished me more than witnessing the powerful special interest groups in full swing as when they thought a proposed rule or piece of legislation might hurt them, giving nary a thought to how the proposal might help the investing public. With laser-like precision, groups representing Wall Street firms, mutual fund companies, accounting firms, or corporate managers would quickly set about to defeat even minor threats. Individual investors with no organized lobby or trade association to represent their views in Washington never knew what hit them. This is just an indication of the perception in New York as to how the operatives in the financial world operate. And then after Edmund Honohan said that, John McGuinness said, it must be contagious because I have seen it here. He's referring to Ireland. And Edmund Honohan replies with, yes, that is it. It has traveled fairly quickly. And he goes on to finish the meeting. Can I please invite everybody to put their hands together to thank Mr. Edmund Honohan, the Master of the Court, for speaking out, for Mr. John McGuinness, TD, for hosting that session, and many, many others, speaking truth to power, the kind of power that is sinister power, power that is not born in democracy, but power that's born in the space and the land of kleptocrats and oligarchs and the powerful and the lobbyists. And in a moment, we're going to hear from Mr. Seamus May, who I can tell you his speech, his TED Talk speech about kleptocracy and the oligarchs is something to be beholden. But can I first, once again, invite you all, please, to salute the work of David Dayen and of John McGuinness and of Edmund Honohan, the Master of the High Court. Please, please do. Thank you very, very much indeed. We have to build on the momentum that's being created here, folks. We can do this. We can make a difference. This is how things happen. You know, we do not live in banana republics. We live in democracies. We have to learn how to get organized and fight back. That's what we're doing. That's what this event's about. And we can get inspiration from the three people that David's book's about, and David's book, and everywhere else we can find it. And I can tell you somewhere else you can find inspiration. The TED Talk that Seamus May gave some time ago. I'm going to put a link to it in the chat. Meanwhile, Mr. Seamus May, the microphone is yours, sir. Thank you.
Yeah. Thank you very much, Andy. You're very kind with all those lovely words. I just want to say first and foremost that I am one of the less qualified people to speak on the minutiae, the nitty-gritty of all the wrongdoing, the fraud and the deceit that has been taking place in Irish banks. People like Cormac Butler, the Master Ed Honehan, and several more people would have a lot more expertise in that specific area. So I am not going to dwell too long. I'm not going to hold you too long, but I just want to give maybe more of a general perspective as I see it. I have been in business now since a teenager, so about 50 odd years. And most of it has been at war or basically been attacked. I was in the cement concrete quarrying sector of Ireland, in Ireland. And, you know, in more latter years, I see the carry on that has gone on in that sector. It's identical, same as what's going on in the agricultural sector. The same thing is going on in obviously, and of course, in the banking sector. So just to underline that my specific expertise would not be the nitty-gritty of what has been going on. Now, I think it was David said earlier on, he mentioned Rohit Chopra, who, when I met him, he was a federal trade commissioner in the States in 2018. And there's the Attorney General of the States, Jonathan Cantor. I've just spent almost 2 weeks over there. And Gudsing, I think, is the name of the guy in the SEC. And I was going around with all these people and trying to make a mark. And I find that there are very impressive people in powerful positions in the States. That's my initial reaction to it anyway. Problem is that, you know, in our country, in Ireland, after my 50 odd years, I can safely say that every sinew of our society is corrupt. And, you know, by that, I mean, I don't necessarily always mean raw naked corruption where money is changing hands in envelopes or whatever. I mean, I believe, and I think this will probably you know, resonate with people in other countries. The biggest problem that we have with corruption in Ireland is not the raw naked type. It is what's known as legal corruption. And just if I could quote a term here, the Corruption Perception Index in Ireland does not account for what may be termed legal corruption, which takes many forms and includes cronyism, patronage, and state capture, when powerful groups manipulate policy formation to serve their own interests rather than the public interest. And when I first came across that, several years ago now, you know, I was fascinated with it. And I suppose that's what led to my TED Talk, which was originally supposed to be on banking and bringing competition into the banking market, etc. But no, when I got the opportunity, I broadened it out. And the title was Ireland, Democracy or Corpocracy. And it's my belief, and I see what has happened over the last, say, well, 20, 40, over 40 years since I left college in University College Dublin. And I see the way that, you know, maybe the political parties then, there was a lot of democracy about, but I have seen that eroded time and time again. And we're now getting politicians, and I'm saying largely because there are some very fine politicians in every jurisdiction, but we're now largely getting politicians that are just puppets, puppets to their leader. In our case, we have three leaders. We have Micheál Martin, Fianna Fáil, we have Leo Varadkar, Fine Gael, we have Eamon Ryan, the Greens. These are our current leaders. I would say that in inverted commas. So these guys have their TDs under them, all under the thumb. But like, who has the politicians under their thumbs? Because certainly in our country, and I think I'm probably able to say it about other countries, our leaders are mere puppets for a greater force. And to me, that force is, you know, corpocracy, the corporations, the globalization of everything. And just to talk about, make a few points. Chris Menton, back in the day, he interviewed Steve Keen, Professor Steve Keen, who's from Australia. And he asked in relation to banking, he said, much of the reforms that you, Steve Keen, that you recommend are predicated on reform of the banking sector, cutting the banking sector down to size. How realistic is that, given the nexus between the political class and the banks? And Professor Keen replied, we have to break that political nexus. It's false, because the reality is finance is a cost of doing business. It's not a profit center. Ultimately, the financial sector should be the servant of the rest of the economy, not the master. But at the moment, it's the master of not just the economy, but of the politicians as well. So to break the nexus, we need a complete political shift. Now, and Nicholas Shaxson in his book, The Financial Curse, went on, you know, in the era of financialization, the corporate bosses and their advisors and the financial sector have moved away from creating wealth for the economy and towards extracting wealth from the economy using financial techniques. Shaxson describes the finance curse as the idea that once a financial sector grows above an optimal size and beyond its useful roles, it begins to harm the country that hosts it. Finance turns away from its traditional role serving society and creating wealth, and towards often more profitable activities to extract wealth from other parts of the economy. So we see not just the banking sector that is completely out of control, but, you know, all of these sectors now that are controlled by the big corporations are gone rogue. They're out of control. And, you know, in Ireland, again, there's so many people on front of the courts. Nobody really can get a solicitor to represent them. And I mean, to represent them in an effective way. They'll certainly take their money. But in Ireland, we are, you know, blocked from getting access to justice through several different means. Say third-party funding, which is available in the UK and the States and Australia and everywhere else. It's illegal in Ireland. So people that are in trouble can't even get third-party funding to help them run a case. Neither can they do a contingency fee arrangement with a lawyer, because again, in Ireland, a contingency fee is illegal. And we only now, a few months ago, have introduced representative actions, which is maybe more commonly called class actions. But unfortunately, they're not retrospective. So nobody sitting at this meeting here, and certainly in Ireland, nobody can you go in and get involved in representative action, because it only started in July. So like, there are a lot of the issues that we have to deal with. Now, if you look at the Irish Constitution and Article 45, which is a directive principle, and by directive principle, I mean it is not the Constitution proper, but it is the responsibility of the Oireachtas, i.e. the Parliament, to introduce laws to enshrine these principles. So Article 45(2), that the ownership and control of the material resources of the community may be so distributed amongst private individuals and the various classes as best to subserve the common good. Well, that applies to credit, and who's allowed to create credit, and who owns the asset of being able to create credit. And of course, that has been deprived from the people for years and years. And now there's far less banking institutions in Ireland than there were. Ulster Bank have gone, KBC have gone, and several others before them. But interestingly, the subsection 4 goes on to say that in what pertains to the control of credit, the constant and predominant aim shall be the welfare of the people as a whole. Now, we know that's not the case. It's not the case in Ireland. It's not the case in the UK or America or anywhere else. So we have a problem. As all of us, we have a problem. We all know what it is. We know what the banks are doing. We know what other sectors are doing. They're behaving criminally and illegally. In a lot of the cases, there's criminality going on in several different sectors. But how do we deal with it? And that's the big issue for us all that we must consider. It's anyone that's on here tonight from Ireland will know that, like, we have presented umpteen times in front of the Finance Committee and other committees, and there's just nothing doing, because at the end of the day, it's down to the leaders who are in government to do something about these things. We had a half-arsed banking inquiry. I think it was the Public Accounts Committee, but that went nowhere, and nobody went to jail, and nobody will. So I don't know how we as a group, and there's lots and lots of us, not just here, but lots of related groups, how are we going to break this nexus? Because we have got to bring back democracy as it should be. This model of corporatocracy is not going to last. It's going to destroy society, and it is currently destroying society. So there are just a few general comments, because I think we have to look and focus at solutions, and how in the name of God can we possibly, shift Fianna Fáil, Fine Gael, the Conservatives and Labour, the Republicans and the Democrats. It's the same old game in town, and they're making fools of us. So that's in essence the sort of message I wanted to get across.
Can we please show our appreciation to Seamus? Thank you very, very much indeed, Seamus. And please take time, folks, to watch and listen to Seamus's TED Talk. I put a link to it in the chat. It's outstanding. It's absolutely outstanding. It provides a big picture, high-level insight into why things are happening the way that they are. Folks, I'm going to share my screen because I want to share with you my direct response to the challenge, the point that that Seamus has just pointed out. He basically asked us, how do we respond? What do we do? Now, there are many, many answers to that question. I'm going to answer that question by talking about a man who has his critics, but a man from the 60s who was one of the most remarkable campaigners there's ever been. A man called Saul Alinsky. You may well have never heard of him. I hadn't heard of him at all until a guy called Greg Leroy, who, by the way, David, rates you very, very highly, sir. Greg Leroy runs an organization that produces a database called Violation Tracker. And Greg Leroy in Washington, D.C., told me about this guy, Saul Alinsky, who was a remarkable change maker in Chicago. And if you read Saul Alinsky's work, or if you watch the recordings of his speeches, he basically says, get organized. You've got to get organized. We have got to get organized. We've got to get organized internationally. To my mind, folks, there's a very natural triangle. Ireland, the UK, USA. I genuinely believe that if we carry on like we are here, we can create a force to be reckoned with through Ireland, the UK, and the USA that will hold the people to account that need to be held to account. I encourage you to take time to learn about the work of Saul Alinsky. He basically provides a roadmap on how to make real serious change happen. Thanks so much, Seamus. We're now going to hear for a few minutes from Cormac Butler. Like Seamus, like everybody speaking tonight, He's somebody I've learnt to admire and respect, a phenomenal degree of subject matter expertise. He really, really knows the subject very well. Cormac, you've spoken at our events before. Please do share with us what you feel to be the key points that you want to get across in relation to this scourge of foreclosure fraud, land registry fraud, and so on. Cormac, over to you, sir. Thank you very much.
Thank you, Andy, for inviting me to say a few words. What I'm going to focus on is some of the practical areas that we've dealt with, and it may help you if you're in front of the courts on a possession order or anything else. My comments probably apply to the UK. I'm not great on US law, but I think there are similarities. But if I give you the practical experience, experts like David Dyan might be able to relate to it and see how it applies in America. First of all, Edmund Honahan raised the issue of land registry and what happens when you are registered as the owner of a mortgage charge. So you've borrowed money from a bank, and the bank has sold that charge to a vulture fund, and the vulture fund are the registered owners of a charge. In Ireland, under the Registration of Title Act 62(7), the registered owner of the charge, which in this case would be the vulture fund, not only has he to prove that he's the registered owner, which is easy to do, but he also has to prove that the loan went into default. And one practical issue that we've come across is we've said to the judge, can we have the original lender in the dock here? And they've come back and said, no, you can't have the original lender. The new owner is this particular fund, and they are the new owners, so there's nothing more you can do about it. And we said, well, we dispute the demand, we dispute the figure of the demand. It's based on clauses which are themselves unfair. And they come back to us and say, well, there is a new Irish legislation. It's Section 20 of the Criminal and Civil Liability Act, and basically it overcomes the issue of the Banker's Book of Evidence. And all they have to do is, all the vulture funds have to do is say, well, our records show that this amount is owing, and you can't do anything about it. You can't even challenge it because of the conclusivity of the register. And what we've said is the demand letter, and this applies, I think, to the majority of people in Ireland and the UK, the demand letter is flawed for a few reasons. The main one is that the interest rate is variable, and the vulture fund are not able to explain how that interest rate is calculated. And secondly, there is an issue which was discussed by Tony Lawler and I think Michael Power in a radio interview. We'll get the link over to you. But essentially, the value of the loan in legal terms cannot be greater than the recoverable value. What that means in plain English is the banks lent more than they should have lent. And the value of the loan is the recoverable value is an awful lot less than what they should have lent. And there is case law on company law which states that the most the bank can recover in those circumstances is the value of the loan, the recoverable value of the loan. And our argument is, well, we accept that argument, but the recoverable value of the loan must be what the vulture funds paid for it. And they've come back and said, well, that's a private matter between the vulture fund and the bank. And we've said it's not a private matter, because if the vulture fund buy a loan for 25% and we bid 26% on it, then we should be entitled, the shareholders would say that the highest bidder should get the loan. Sorry, if the vulture fund, I think I got that right, yeah. If the vulture fund said we're going to buy the loan for 25% and we say, no, we're prepared to pay 26%, then the bank is required to give the highest bidder the offer. When the loan is transferred to the vulture fund, that offer or right for the borrower is extinguished, and that makes the transfer unfair. So there is a clash between the Registration of Titles Act and the unfair term. If the bank says, well, the Registration of Title Act is conclusive that we're the registered owners, then you can say, well, that means that the actual transfer clause is unfair and therefore ineffective. And judges have accepted that argument. It's important to emphasize that judges have accepted that argument. They've also accepted the variable interest argument, and that is if a bank decides that it can charge a discretionary interest rate, then they're entitled to, the vulture fund is also entitled to charge a discretionary interest rate. There is a case coming up in Ireland on that matter where a vulture fund has charged 8.5%, whereas the original bank would only charge 4%. That too is an unfair term, and we have argued that. And we said that we need the original lender in here to explain how they decided the interest rate and what rate they could charge. So the sum of all this, or at least the main point I'm trying to get across to you is, if a vulture fund turns up and says we want to prove that we're the owners, you can say, well, we're not going to challenge that. You appear to be the owners, although what you've bought is questionable. We also say that the demand is X amount of money because we've issued a demand note. Then we simply say, well, you didn't issue the demand note, or if you did, you use records that you didn't calculate yourselves. Therefore, you don't know how these figures are obtained. And that should be enough to get the case into what's known as case stated, where the judge will delay it and wait until witnesses appear, both for the bank and on behalf of the defendant. And the likelihood is that the vulture funds will not call the original bank in. So there is the prospect that they will fold on that particular point. Now, it's not a guarantee of success, but it's something that you should consider. So the 3 points are, first of all, the variable rate of interest is questionable. In Ireland, we have a tracker issue, and the banks say the loans are variable, they're not tracker. What that basically means is the loans must be discretionary, which means the banks can charge whatever rate they like. If they use that as a tactic, then you can say that the term is unfair under European legislation because banks cannot charge a discretionary interest rate. Secondly, you can challenge them on the principle. You could say to the courts quite legitimately that the fair value of the loan is the price that the vulture funds have paid for it. There's no other value of the loan. And if banks have lent more money than they should have lent, there is contributory negligence on the bank's part. And there is case law in Ireland supporting that. And the third point is that if the vulture funds say, well, we are conclusively the owners of this particular loan, you can say, well, if you are the owners of the loan, the actual transfer is invalid because prior to the loan being transferred, the customer had the right to buy the loan, provided he quoted above what the vulture fund were prepared to pay. That right is now extinguished on transfer. And under European unfair terms legislation, a transfer cannot cause your rights to be extinguished. So there are 3 blocks you should consider if you're at possession proceedings. Judges are coming around to it. What I have found in practice is that sometimes when these particular topics go to solicitors and barristers, the barristers come back with very long-winded statements of claim going into hundreds of paragraphs, but for whatever reason they don't mention these points. Now, I don't know why, but certainly they're coming up in lay litigant cases, and judges are more persuaded than they were. So to summarize, Ed Honan has opened up this issue of the Registration of Titles Act. If the transfer clause is unfair, then the conclusivity of the registration of titles won't work for the vulture fund. The amount that they can claim is restricted to the recoverable value of the loan, which basically is what the vulture funds have paid for it. And thirdly, the interest rate may be unenforceable. So you can say to the vulture fund, you're going to have to issue a new demand letter. Then we can start and see if you're entitled to it. Okay, that's all I'd like to say for the moment. Thank you.
Cormac, thank you so much. You've squeezed a hell of a lot into just a few minutes there. We're all very, very grateful to what you do. I've learned over recent months that Cormac's an absolute font of knowledge in terms of the detailed, technical, this is what you need to know knowledge that's valuable to so many people. Can we please show our appreciation to Cormac? We're then going to go to David Dayan for his kind of closing remarks because David's got to jump off quite shortly. Then we'll be going to Steve Middleton. So the phase is pretty fast. Brace yourself some more. But first of all, let's thank Cormac for his contribution to the session. And Mr. David Dayan, if we can go back to you, please, for your closing comments, and we'll make sure you get a recording of the rest of it. David, back to you, sir. Thank you.
That would be great. Thanks. Thank you, Andy, and thank you for everyone who spoke. I was thinking about, as I was hearing from Cormac, what a time warp this all is. I mean, these are the kinds of statements that I would hear. You know, I covered this issue in the US in real time in 2009, in 2010, when these issues were paramount, when there were millions of foreclosures being pushed through the system in what is called the rocket docket, where they would have court proceedings in a hallway in various courtrooms in Florida, courthouses. And you know, there were these meetings where people would be saying almost precisely, almost verbatim, the kinds of things that Cormac was saying. This is what the law shows. We're starting to see judges pay attention to this. The banks or the vulture funds or whoever claims to be the true owner of the note and the mortgage, they're claiming this. This is wrong for these reasons. All of these things, it's like deja vu. We have heard them in the U.S. for many years ago, going on more than a decade ago, and now we're you know, what I'm learning is you know, we're experiencing these problems once again in Ireland. So you know, I wish I had some sage advice to give you as you work through these terrible problems. You know, hopefully the experience of the protagonist in my book can be a resource and more important, a source of inspiration for people. You know, one thing I say at the end of the book is that movements, activist movements, they're like waves crashing on a shore, and each one gets closer and closer to its destination. And sometimes they come up short, but the people behind them maybe go a little bit further. You know, the foreclosure fraud movement ended up inspiring the Occupy Wall Street movement,
Wow.
which ended up inspiring the Bernie Sanders movement, which ended up inspiring a whole host of other things. So you know, you see that these, even if the end of my book, I will readily admit, is unsatisfying. You see that it led to other points of activism, other movements in the U.S., and hopefully will lead to you know, the kind of circumstances that you're experiencing in Ireland, with a better resolution where people are actually paying attention. So I really appreciate you taking an interest in the book and my work. Thank you very much. And I wish you best of luck. And Andy, please keep in touch.
We certainly shall. And just before you go, David, I'm going to salute your work, sir, by making reference to a quotation that I think about and refer to at least weekly, quite literally, at least weekly. It's one of your country colleagues. I'm sure you'll recognize who that is straight away. The gentleman said back in the 60s, and please think about these words and how these words apply to all of us. Robert F. Kennedy said, every time we turn our heads the other way, when we see the law flouted, when we tolerate what we know to be wrong, when we close our eyes and ears to the corrupt because we are too busy or too frightened, when we fail to speak up and speak out, we strike a blow against freedom and decency and justice. And in all sincerity, David, your book speaks that message so well. Can we please once again show our appreciation to David before we go to Steve Middleton? David, thank you very much indeed, sir. Thank you. Thank you very much.
Right.
It's been great to have you with us. Mr. Steve Middleton, then we're going to go to Mark Wright and or Chris Gordon. Not quite sure what the order is. I figure we're going to be wrapping up the kind of presentations bit in about sort of 15 minutes or so. But for those that want to hang on a little bit longer to chat, let's do that. The channel's going to be kept open. Mr. Steve Middleton, to you, sir. Thank you.
Thanks, Andy. I'm going to be very brief and just introduce Chris Gordon's case, which I think, again, goes somewhere to explaining just what's going on, certainly in the Northern Irish courts. And it does make you wonder, as Ed Honohan raised when he was over in New York, just and when he was in front of the Finance Committee the other week, just what's happening with the lawyers and the barristers and the courts in terms of applying the law. We, as many of you know, have been working on frauds in relation to Ulster Bank fixed rate loans. So this has not been a big focus, this area of the title, but we I started looking into various books the other week to have a look at on this area, and I came up with this one by a guy called Mr. Amoir, which is about registration of title in Northern Ireland. And the points in it are quite fascinating. They seem very, very basic when it comes to what you can and can't do in terms of property and property title. If I can just share my screen very briefly, Andy, if that's all right. Hopefully it should come up. This is where it goes wrong, because I'm trying to share my screen. Let me see, show all windows.
If you first of all find the document or the thing you want to share, and then click on.
I had the document open. Can you see it now?
No, we can't see it yet.
Right, on my screen, the document's open.
So what that means is, if you now click on share screen, and when you get the options about what bit to share, find that the bit to share, okay? But don't worry, the plan B is copy the link and put it.
Well, plan B is, I'll just talk you through it then. Effectively, this is a book by a chap called Arthur H. Moir that I bought, and the book is no longer published. It's not that easy to get. It's called A Guide to Land Registration Law and Practice in Northern Ireland. The Law Society actually states about this, that Moir on land registration is the standard textbook on land registration law and practice in Northern Ireland. It offers the conveyancing solicitor guidance and assistance across the whole remit of registered conveyancing. It also contains invaluable precedents. So I went into that, began reading through sections of it that were relevant to this, one of which is conclusiveness of the register and the principle of conclusiveness. And this is where he goes on to say that in Lord Watson explained in Gibbs v. Messer 1, the object of registration of title is to save persons dealing with registered proprietors from the trouble and expense of going behind the register in order to investigate the history of their author's title and to satisfy themselves with its validity. And he goes on to say that savings is otherwise provided by or under the Act. The register shall be conclusive evidence of the titles shown on that register and of any right, privilege, appurtenance or burden as shown thereon. So just keeping it in very simple terms, what he's actually saying, Mr. Moir, is that if you go onto land registry and check who the owner is on the piece of land, you should know who has the rights to deal with that land. If you check on who has a registered burden on that land, as in a mortgage or something similar, you should know who has rights to act on that land, both on the land as it stands and in receivership. That seems very, very straightforward. Yet that's not what's happening at all in Northern Ireland. And this comes to the case of Chris Gordon v. Ulster Bank, where he has a document at Land Registry telling that Ulster Bank is the owner of his title. And recently, the bank started trying to sell off properties that are under receivership at present without Chris's agreement or knowledge. This only happened shortly after we brought out the issue about the Ulster Bank fraud, of which Chris is a victim. And we ended up in court in Northern Ireland, Chris representing himself very well as a litigant in person, where he was challenging the bank, suggesting that they were trying to force through the sale of his properties, known as the victim of a fraud. So Chris then went on to do some digging about the land registry, and I'll let you go on to tell them, Chris, just what you found and what's happened since then.
Yes, thanks, Steve. So can everybody hear?
Yes, indeed. Yes, indeed.
Yes. Okay, so everybody knows me probably through the meetings about the Ulster Bank fixed rate loan swaps, is this asset protection agency, all those different things, West Register changing its name to UBSIG before it sold all the loans to Cerberus in the first place on the 28th of September 2014. In Northern Ireland, we've got the Good Friday Agreement. In the Republic of Ireland, they have their economic rights in Article 1, Protocol 1 of the ECHR. And both Ireland, North and South, still acts under, and still the law that's applicable for properties is the Law of Property Act 1881. I believe in England, Scotland and Wales, you've got a new law in 1925, okay? So the Law of Property Act 1881 is the applicable law in the North. Just around the time after we got to prove finally what had happened in 2008, 9 and 10, with the fixed rate loans, thanks to your good self, Andy, and Steve and Mark's, and everybody that was associated with pushing that at that time, they started to sell what was left, okay? So nobody here got into the IRHP review because of the cover-up to do with the swaps in the first place. In 14, our loans were novated between the 16th of December 14 and the 12th of February 15 to Promontoria, Iran, okay? So in Land Registry, I had a receiver, I won't say the name, and I had the bank, the lender, Ulster Bank, which is NatWest now. So what started out as a simple injunction on me trying to say, you can't sell these because these guys over here finally admitted after 11 years that you ended up with the loans in the first place based on a fraud in 2008. So I'm injuncting you on that basis. The bank turned up to court and said, it's not us. So that was the first point. Okay, so the judge said, well, you need to join in the receivers to your action, Mr. Gordon, and bring them here because they're the ones selling them for you, i.e. for me. Now, the Receiver Act, I believe, says that the receiver is always acting for me. I had off-the-record conversations with the receiver and said, who are you selling these for? Because I'm telling you to stand down, and they wouldn't answer the question, okay? So the properties are being sold at the minute. Nobody would answer the question in the court to the judge or to me. So she said, okay, you could join them into the action, bring them to court, and find out who it is they're selling them for. They wouldn't answer the question, and solicitors turned up at the last hearing with Steve and the Marks were both there. And again, it was at that we triggered a point of inquiry that I hope is of benefit to everybody watching, okay? The judge said, okay, the receivers are your receivers, so they're selling them for you, and you're saying that they're not selling them from you. So that's the first point, yes. So then the last hearing, they brought another set of solicitors who are acting for the receivers. So you have two sets of solicitors and barristers in the courtroom, and nobody will tell me, after proving what we proved about Ulster Bank, West Register, Asset Protection Agency, IT glitch, margin credit, all the different things, who did all these things through the years, who is selling my properties? So again, due to my nature and everybody that I work with is very helpful, we started to go into the Land Registry, of which I have an account in Northern Ireland. And I started to research all these different land registration acts and things that we've got here where people can't impersonate. It's an actual 3-year go to jail criminal offence for impersonating somebody that's not on the land registry deed in Northern Ireland. That's under the Land Registration Act 1970. So we've got two sets of barristers and solicitors who won't tell me who they're selling them for. And I've submitted formal questions. But the key point here is, Andy, and everybody watching, that there's been £10 billion worth of loans sold in Northern Ireland through Project Eagle, Promontoria Iran, Promontoria Chestnut, Promontoria Henrico, Promontoria Scarf, Promontoria Oyster. And no matter what properties I check for my customers or friends, Promontoria or Cerberus are not in the Northern Irish Land Registry as the legal owners for the loans that have been sold since the 12th of February 2015.
Chris, you've got to go over that again. Say that again.
Okay, so there's been £10 billion worth of loans sold in Northern Ireland, okay? Yeah. Through Project Eagle, Promontoria Iran, Promontoria Chestnut, Promontoria Henrico, Promontoria Scarf, Promontoria Oyster, and others, okay? But they're all associated with Cerberus. And then to hear David say tonight, okay, I'm really angry, that this was a scam that the American banks had worked out in the first place, that they've rolled out over here. And until tonight, I didn't know this, okay?
Got it.
I've been trying to find out what's actually going on, but not one property or loan that's been sold in Northern Ireland has had an assignment carried out in land registry. And in Northern Ireland specifically, there's an assignment clause that the loans can't transfer without the consent. Now that's there because of the Good Friday Agreement protecting our economic rights that were actually taken away from us by the British government in 2008, which because of the cover up by the FCA, nobody knows. But that's what's happened. Today, nobody in land registry is actually selling the properties. It is this hidden, it's like the Wizard of Oz, where there's somebody behind the curtain has sold all these properties and not one's registered. Now, the same thing goes for the South, because they had their economic rights in the ECHR in 2008, when what the government did to them was did to them. And they have been assigned to Cerberus without realising as well, they were already assigned without their knowledge or consent in 2008 to 2012 to the Asset Protection Agency. So I don't know where we go from that, because this is a discovery tonight, listening to the guy David and the chain of title, and thanks to friends and people that assist me that come to court to help, but none of the sales in Northern Ireland. So on top of your Ulster Bank fixed rate loan fraud, your West Register fraud, your Asset Protection Agency fraud, your denied margin credit fraud, your Consumer Credit Act, they asked you to sign exemptions after they knew they were going to put you out of business in 2009. On top of all those things, to find out 15 years later that all the properties that have been sold in the last 8 years are effectively illegal under the Land Registration Act, and they've been impersonating the owners all along. It's just too big for me to try and handle the scale of it, but that is what's happened. I can send hundreds of documents of searches I've done, and this is a police thing. This should not be for the TTF or all these meetings that we all have, or we go to the FCA and report things and get ignored. We go to other authorities and we get ignored. This is what they're doing today.
This is I'm not often speechless, but this is we're talking here land registry gate, aren't we? We're talking here about like I don't really know how to describe it.
Can I just throw something a little bit further in, Andy?
One quick point. Bear with me, Steve, just one quick point. I know for a fact that the regulators coordinate internationally. What chance is there that the regulators in the US didn't get to tell the people in the UK and or Ireland about what was happening in the US years and years and years ago? I'll leave that thought there. Steve, yes, please. Thank you, sir.
It's just a brief point. Sorry, that I don't think Chris mentioned it, and I forgot to. Was that Chris rang the receivers? So he has a receivership deed, and there are only 3 parties on the receivership deed. Chris Gordon's company. There is the receivers themselves, OKT, O'Connor Kennedy Turtle, and there is Ulster Bank. They are the only parties legally allowed to act under that deed. When he called the receiver, he admitted he was not being instructed. He hadn't taken instructions from Chris, and he was not being instructed by the bank. What he let slip was he was taking instructions from a firm called A&L Goodbody, who act for all of the Cerberus arms in Northern Ireland, and who had been acting for Promontory Iran in trying to sell the properties. Now, what gets even worse than that is that when Chris then questioned their link to Promontory Iran, they brought in A&L, the OKT, the receivers brought in A&L Goodbody, who'd been instructed them to sell the property to represent them in the action Chris is now bringing against them, and weren't answering any questions on conflicts of interest. And what makes it even worse is, in the background, although it's not advertised anywhere on their website, Elvena Graham, who was a director of GRG, head of the bank in Northern Ireland, Ulster Bank, who is now head of tourism in Northern Ireland, still acts as a consultant to A&L Goodbody. So you've got the ex-head of the bank in Northern Ireland carrying out all these frauds and atrocities, advising the lawyers who are acting to recover all the properties, even though they have no legal right to act on those recoveries.
Steve, thank you very much. Thank you very, very much indeed. Folks, it's 20 to 8. I'm happy to keep this channel open till, let's say, 8 p.m. UK time. Please, let's go to the kind of, all feel free to chip in with your comments and questions. Just before we do that, let's quickly go to Mark Wright. Mark, could you briefly mention what you believe to be the case in relation to bank forgery stuff? There are some people on this conversation who may be quite shocked about what you're about to say. As succinctly as you can, please, Mark. But please tell everybody about the signatory forgery situation. Thank you, Mark.
Yeah, thanks, Andy. Dave, that was brilliant. Can you hear me okay?
Yes, we can. Yeah.
So basically, with regards to signatory forgery, the difference between when myself and Steve Middleton put the report together for the signatory forgery campaign that Julian Watts was doing, I was very lucky that I was able to actually name the signature forgery trainer at NatWest Corporate and Commercial because I work with her. Separate to that, myself and Steve, we were introduced to two senior relationship managers who both joined the bank a year apart, I think, Steve, wasn't it? And put simply, their week one induction was being taught how to take the customer's original signature on the ISV, image signature verification, and put that onto any document that they needed in order to be detrimental to the customer. That could be providing false documents to the court so that the bank would win hands down. It could be various numbers of things. And the fact of the matter is, and I'd put this to David, if you were the head of the regulator in the US and somebody came to you and said, this is the name of the signature forgery trainer at a major bank who is forging signatures to enable the bank to win in court to steal that property, or the bank to ensure that they would be able to take that property. And the beauty of this is the fact that both of the whistleblowers that have come to Bank Confidential were both trained a year apart, and their week one induction was exactly the same. Let's show you how to forge a customer signature on any document they require. Now, if it needs to look old, they'll put it through various cycles, and they'll reduce the toner on the photocopier. They'll maybe put it on the slant through the fax machine. But that is what is going on within a certain group. Now, also what makes that even more interesting is that disclosure has been given to the UK regulator. But Steve will probably want to chip in now and basically state that every single disclosure I have given to the regulator at this moment in time, we believe has been wiped from the servers totally. And bearing in mind that not only have I given the FCA the name of signature forgery trainers, but also the number of whistleblowers that I have who have stated, well, I think I forged signature about 15 times. Well, I think I forged signature this amount of times, but that's what they were instructed to do. And they were told it was to make the customer's life simple, not to have to drag the customer into the branch. But they didn't know what documents, what these meant to customers, and the fact that these could be used in court. But it's absolutely rife. And to my knowledge, and Steve pursued the FCA for over a year to try and get one reference number for one of my disclosures. And you have to bear in mind, Dave, that I actually worked for this group for 25 years, know them inside out. We have over 50 whistleblowers from that group that come to Bank Confidential, back up all Steve's arguments. So, that is as bad as it gets here. And Steve pursued for a year, time and time again, to the executives and ask him how many disclosures are actually registered at the bank that I worked for 25 years, so knew inside out, and I don't exist there no more at the FCA.
Mark, thank you for sharing that. Steve, do you want to just chip in with any sort of comments supporting that before we then go to Gertch and Nigel? Steve?
Yeah, well, I mean, one of the chaps we met was a union rep, and he went to his regional manager because he said he gave him the 10 names, and he said those 10 people are all forging signatures. He said those 5 people there I'm representing in upcoming tribunals where you're sacking them for being caught out forging signatures. Those 5 people there are 5 of your top performers in the region who forge signatures on a weekly basis, and it's known by you and everyone else that they do it. So can you tell me why when people are caught out, you're getting engaged in removing these people's jobs and sacking them when you've actually trained them to do the signature forgery? Unsurprisingly enough, within a matter of months, he had false allegations brought up against him, and he was pushed out of the bank. I mean, it's just systemic at RBS. It continues to be systemic. But as Mark has noted recently on Twitter, we do think some of these things are coming home to roost, because RBS directors at the moment are selling off shares at a very, very serious level, including the new CEO. And that's now been picked up by the markets. And what's Mark is clearly alleging is correct. This basically is insider dealing. These are people who know about all of the allegations, including the signature forgery, the Ulster Bank fraud, and other things that have been raised. And directors on the board are offloading their shares en masse before these things come out, and the shares take the dive we know they will take.
Steve, thank you very, very much indeed. One quick housekeeping point. It occurs to me that quite a lot of you don't actually know each other, because we've got a lot of guests here from Ireland, but a lot of guests here from the UK that you may not know each other all that well. Please do feel free to put your contact details in the chat if you want to. For example, it might be your LinkedIn profile or your email address or your phone number or whatever you want. Whatever goes in the chat will be circulated amongst the attendees. So if you want people to be able to contact you, please do so. For example, if Steve put his contact details in the chat or the Bank Confidential website address, people can make connections, etc. Because I know a lot of you have got a lot of knowledge that's of use to everybody else. And if we can do something to share that knowledge around us, we all end up knowing more. The more we know, well, you know the saying, knowledge is power. We're going to go to Gertch. Gertch, please be as succinct as you can. Same for Nigel and same for everybody else that follows, so we don't run out of time. Mr. Gertch Samra, please share your thought. Thank you.
Good evening, everyone. It's basically following on from what Chris said about Cerberus, Promontoria, and AL Goodbody, and who the receivers are working for. Okay, so the scenario is we want to go and borrow £100,000, right, to buy a property. Right, the bank makes us sign a mortgage. Yeah, right, and because we put our name on that mortgage, 20 years down the road or longer, right, somebody comes along and says, we're taking your property because we've got this mortgage. Yeah, right. We go to court and our name's on that mortgage, and somebody says we owe them money, so therefore we've got to give them our property. Right. And there seems to be no way out of that mortgage agreement. Right. Yeah. So that's the mortgage agreement that we used to get £100,000. Right. Now, if you're going to get £560 million, like Promontoria Enrico did to buy the Enrico portfolio, then you would think that that mortgage that they're going to get that £560 million on is going to be a bit tighter than the one that we use for £100,000, wouldn't you? Right. Well, it is. It's much, much tighter. Right. So basically, what happens is these vulture funds, as they call them, right, with their SPVs, they're set up and they go out and they borrow Promontoria Enrico borrowed £560 million from Morgan Stanley Bank. Okay, so that happened on the same day that apparently Enrico bought the portfolio of loans with at least 3,000 properties from Clydesdale Bank and National Australia Bank. Right. Now, on that same day, obviously, they also entered into a mortgage agreement with US bank trustees, who were the security trustee stroke agent for Morgan Stanley Bank at Promontoria Holding BV 93 and others. Okay. So those parties own all the rights to everything. to our mortgages. Whatever's supposed to have been transferred from Clydesdale to Promontoria Enrico that day was simultaneously all assigned over to US bank trustees who were holding it on behalf of the other parties, which is normal practice when they do securitization, etc. Because, you know, if 10 people all chip in to buy something, then you're not going to put 10 names on every security. So you have a trustee, security trustee, and they hold the title and the benefit and everything for the 10 people. So the Cerberus entities set up in Dublin, all of them are set up under Section 110 of the Irish tax status, which is for companies that are set up for the purposes of public securitizations. So AL Goodbody are their lawyers for most of these transactions. However, as far as I can see, neither Chestnut, Oak, or Enrico, which are the three Clydesdale related portfolios, none of those have gone into any public securitization, but they're set up for special tax status in Ireland to do that, right? And they're the promoters of those securitizations, right? So technically they have gone into a securitization, but from what I can see, the only parties involved are a parent company in the Promontoria group, and it was Morgan Stanley Bank. Right.
Got it. Thank you.
Yeah, so they've done that over there, but in the UK, they're acting as if they're the lender. Right now, as part of the promoter for the securitization, they have to be bankruptcy remote. They have to be immune from bankruptcy, right? And that's part of the security for their loan. Right? So what's happening is they're acting as a servicer basically, right, for Morgan Stanley Bank and the Promontoria entity further up.
Gotcha. I get the gist of that. I really do get the gist of that. Thank you so much for explaining it so clearly and so well. Thank you very much indeed, Gertch. We're going to go to Nigel, then we're going to go to Trevor Meelan, and then we'll go to anybody else that wants to quickly come in. We do need to be as succinct as we can at this stage of the event, and then we'll start bringing the conversation to a close. Mr. Nigel Keynes, as succinctly as you can. Thank you.
Just very, very briefly, I wanted to mention to Steve Middleton and to Chris Gordon that I have a publication here which I found of interest. I don't know if you can see the title. Is it back to front there?
No, that's good. Registered Law, the New Law. Sorry, Registered Land, the New Law. Yeah.
Yeah, and the author, I understand, is the person that drafted the legislation. And this is the Land Registration Act 2002, and I've delved into it, and I've got a very, very rudimentary understanding of a lot of it. And one thing that came to mind that I can't find the exact place was that it says in there that appearance on the registry is not a guarantee of anything, and it doesn't disbar any potential compensation claims if there's a mistake in the registry, and it goes into quite a bit of detail about the implications of the appearance on the registry. And I was just wondering if either of them if they don't have this publication, whether they'd like me to send it to them, because it's probably a lot more use to you than me.
Thanks, Nigel. I appreciate that, but that would apply in Great Britain. It doesn't apply in Northern Ireland. Northern Ireland have different act on it, and different land registry, and so do Ireland, and rely on slightly different laws.
Yes, I know, but a lot of us are not.
No, I'm more than I'm more than happy if you send it on. More than happy to have a read through and see how it compares. Yeah, thanks for that. Appreciate that.
Yeah. Okay, then I'll send it to you, Steve.
Nigel, thank you. Steve, thank you. We go to Trevor Meelan. After Trevor, we go to Alan. Trevor Meelan, great to have you with us, Trevor. Thank you.
Hi, Andy. Good show. I just wanted to say, with the projects, with Lloyd's BSU, thanks to Joan Finch. Joan sent us, when we were doing the Op Meadow files and Financial Matrix, 20 projects that Lloyds BSU dealt with. And as an idea, Project Avon was £540 million of mixed commercial residential real estate, and it was sold at 34.3% below market value. But it was sold through Lord Lupton, a very senior Conservative who sits on the board of Lloyds Bank. It was sold through his private bank, Greenhill & Co. At 34. Well, he took it 34.3% below value. He then refinanced 144% loan to value and then sold it to Cerberus. I think the interesting thing is, if you look up Lord Lupton, his family crest has got a 3-headed dog on it, which is Cerberus.
Cerberus.
So that's something you can look up. I think we've got other Conservatives. I think we've got to start, we keep going to the regulators and the police and so on, and it's totally corrupt. And I was in a court case 2-3 weeks ago, and it was one hell of a kangaroo court. And I walked out on the judge in the end. But you know, these bent judges are rubber stamping kangaroo cases, and people are losing their homes through it. But I think we've got to look more at the politicians. We keep asking them if they do this and that. You know, Lord Blackwell, he was the strategic advisor to John Major, and he became the chairman of Lloyds Bank. Does anybody know who our new fraud minister is? So
Tell
our
us.
Our new fraud minister is Simon Fell MP, Conservative Minister for Anti-Fraud. He started 5-6 days ago. His other half is Pippa Fell, and she was at Lloyds Bank for 17 years and ended up the Chief Operating Officer. Before that, there was John Penrose, another Conservative. My family used to be Conservative many, many years ago. I don't think I trust any of them now. But we took files to John Penrose, who was the anti-corruption czar for the Conservatives. And meanwhile, we took loads of evidence. Paul Martin Walls has gone through hell. He's Lloyds BSU. His MP is John Penrose. John Penrose said, we'll take it civil. What a load of crap. Avon Somerset Police are covering up the frauds. And John Penrose's other half is Dido Harding. She sat on the court of the Bank of England. And I think we've got to really start questioning more these MPs. Like I say, when you've got, you know, we're seeing it with Moan at the moment, 60 million. But I think when the husband is the anti-fraud minister and the wife sat and became Lloyd's Chief Operating Officer, I think we've really got to say to the government, stop taking the pee, you know. And there we have it. There's my bit.
Trevor, thank you very much indeed for your bit, as you put it. That's really interesting. That's really interesting. I wonder if there's any scrutiny around that decision, but let's find that out. Trevor, thank you very much. We're going to go to the Northern Peasant, Mr. Alan G. Not Ali G, Alan G. Alan.
Right, thank you, Andy. As I made notes, there's a lot to cover, so I'll try and keep it very subtle.
Yeah, very subtle and very brief, please. Thank you.
First of all, in the UK, Companies House and the Land Registry take everything on good faith. That's what everybody needs to understand. Whether it's wrong before they get it, they accept it as is. So messing with the Land Registry and Companies House, they've got no powers to do anything. So it's kind of a flogging a dead horse. Cerberus and BlackRock, Citibank, Wells, everybody who's been named, they all come back through two companies, CSC and Intertrust, whether it's Linklaters, Clifford Chance, and I don't mind if they're named and I don't mind if they're listening because they won't respond, they won't sue me, I can't get anybody to sue me yet. Clifford Chance, Simmons, Allen and Overy, they all come back to use CSC and Intertrust as trustees, corporate services directors, company secretaries and registered office providers. They're all bogus. They all file as dormant. I think it was Trevor, somebody who mentioned they were remote bankruptcy. Now, the problem is with regulators, and HM government used CSC and Intertrust to sell student loans, That was the Department for Education, 3 billion of student loans. Northern Rock stroke NRAM, UKAR, they used the same outfits. So the route of going through high courts, civil courts, it's just pointless, which is why I've gone through the magistrates court route over Companies House offences against CSC and Intertrust, Theft Act and the Fraud Act. There's various segments in there, and it's wrote up. You can go and file one. Okay, it's a private prosecution. If you can keep it simple, that is the route to go, because I can see, I hear everybody's putting in their different parts, and to try and get to the forged documents from them, as we've heard from David earlier, they create them, the robo signing. If you go and look at the accounts of these outfits, and they've done hundreds of these issues, the Promontorius, Promontory Advantage, they all come through these SPVs, and the names of these two companies are on them all. Robo signed going back 20 to 2000 and 2003, 2004, from Northern Rock, GE Money, GMAC, Kensington, Topaz, you name it, they're all there. The route is forget messing around with regulators. I mean, somebody posted Bailey and Breeden, Deputy in Bank of England and Governor, they were at Northern Rock. And finally, if you look at the issues, the Granite offerings and the Air Valley offerings, which were Bradford and Bingley and Northern Rock respectively, if you look on the prospectus issues, they weren't covered. They were unsecured notes. The government didn't have to bail them out. They bailed out their friends, because the people who were out there at Alliance and Leicester, Northern Rock, Bradford and Bingley, Abbey National, they moved over there and they were given the keys to the Treasury to bail out their friends first. And I think that's hopefully summed it up.
Ali, Alan, I need to call you Ali G there. Alan, you've explained those points really well and very clearly indeed. Thank you very much indeed. We're going to start bringing the session to a close, folks. I will, of course, make a few general comments about the session before I finally close it. But does anybody have anything that itching to say before we wrap the session up? Wave a hand at me if you do. Otherwise, I'll assume we're all good. John Goody, you'll have to be very succinct, John. You've got about 45, maybe 46 seconds tops. John, go for it. Thank you. Take yourself off mute first, though. Thank you. That's it.
Thanks for a great presentation. I'd just like to say to you that as a victim of Promontoria Chestnut Limited, foreclosure, a loss of all my properties in Scotland, which has a separate law, I have a document that Gut Samurai, I believe, unearthed, or someone else did, out of Companies House in Dublin, a land registration document, supposedly. I presented it to Land Registration in Scotland, issued by Promontoria in their company documents in Dublin, and Land Registry in Scotland says, we cannot find it. In other words, it does not exist. Prima facie evidence of fraud. The depositing of a title deed in Companies House in Dublin by Cerberus Promontoria, and there is no record of it at the Land Registry in Scotland. There you have it.
John, thank you very much indeed. Tell us more about that in due course. Thanks, John. We're going to go to David Leahy, and then we'll see if there's anybody else that's got something that itching to say before we wrap the session up. What an evening we've had. I mean, it's been very, very rich with content. Mr. Leahy, to you, sir.
Hi, Andy and everybody. You all probably know me one way or another. Brilliant evening. All I wanted to say was you're wasting your time with the regulators. The police and the Mets and the City of London Police have been instructed by government that no bank will be prosecuted. No bank will be prosecuted for any criminal offences. And there is a reason behind that I can't go into now. The only positive thing I've managed to do is commercial liens. I have liens against former prime ministers, MPs, and I went to London last week where 16 MPs were very concerned because they now have knowledge of circumstance. Their job is to regulate. If they fail to regulate, then they commit malfeasance, which carries a sentence of up to life in prison. Because if they don't regulate and they have knowledge of circumstance, we can then go after them with the same process and join them with the initial offenders. So they can have joinder with the principal offenders. We can go after them in the criminal courts. And I've been invited to, in the new year, to have a talk with the Speaker of the House of Lords to discuss what I'm going to do next. So it gets attention. So bear in mind using leans. And if anyone wants to know how to do it, we have a template. That's all I got to say, Andy. Thanks very much for a great presentation. Cheers.
David, thank you. And David, I'm aware that you're working on some pretty big stuff at the minute. I won't say any more for obvious reasons, but I'm aware of it. And good luck to you, sir, in what you're doing. And David, feel free, if you want to put your contact details or some means by which people can contact you, because I think what you just said could be of great interest to lots of people.
Yes.
Thanks, David. Again, I'm going to look at the screen to see if anybody's waving at me. Wave if you do. Otherwise, we'll start bringing the session to a close. Going, gone. In which case, let me wrap the session up. So, we've heard from David Dayan, who wrote his book inspired by the work of 3 ordinary people to expose massive fraud and cover up foreclosure fraud in the States. We've learned tonight through many of our speakers, including Steve Middleton, Mark Wright, Cormac Butler, Seamus May, Nigel Cairns, and everybody that's chipped in. We've learned how things are happening that should not be happening. And the overall sentiment I suggest we must all embrace is we must get organized. We must decide where to focus our energies, because if we try to do everything, it won't be effective. We've got to really identify where to put our energies. We must make really good use of the doors that people like Edmund Honohan have opened up through talking in the Finance Committee just last week. We must use the simple fact that, as Saul Alinsky would say, no politician can sit on an issue if we make it hot enough. That's Saul Alinsky, a direct quote. No politician can sit on an issue if we make it hot enough. That's what we can collectively do as a group of campaigners who are motivated by wanting to do the right thing. And I'll just close with one further simple phrase. Sunlight is the best disinfectant. There really is a great deal to disinfect. There's a lot happening in our society that should not be happening. For those of you who are under the threat or even the reality of having your homes repossessed, please reach out for help. There are people here, I'm thinking frankly of people like Trevor Meelan, who literally go out and help people whose homes are under attack, under threat of foreclosure and being repossessed. Please don't be afraid to ask for help. This is the last Transparency Task Force event of the year. It causes me to want to reflect on the highs and lows of this year. The low is when we heard that one of our volunteers hanged himself. His funeral was the saddest day I've ever had in my life. We never ever want that to happen again. We've got another volunteer, I'm not going to mention the name, who's planning to go on hunger strike Jan 1. I hope to goodness what happened in 2023 doesn't happen again. Let's take it upon ourselves to help each other as best as we can with knowledge, information, insights, experience, encouragement, camaraderie, friendship. What value would you put on friendship? Yeah. It doesn't cost anything. We can all do that. Please do exchange your contact details, reach out to people who can help. If you're Irish, speak to the Brits and the Americans. If you're British, speak to the Irish if you're Irish, speak to the Americans and the Brits. If you're British, speak to the Americans and the Irish. If you're American, speak to the Brits and the Irish. Let's all talk to each other. Just because we're in different countries doesn't mean we're alien to each other. We're fighting the same fundamental issues for the same fundamental reasons. Can I please ask you to join me in thanking all of us for taking time to be with each other tonight and for sharing these insights and these ideas. Let's get organized. Let's decide how to fight, who to fight, when to fight, why to fight, and let's do it. Thank you very much indeed. It's been an honor to host tonight's session. It's been a privilege to run the dozens and dozens of events that we've run to this year. It's been wonderful meeting loads of wonderful Irish people, both in Dublin last week and in New York a few weeks ago. We can make a difference. We really can make a difference. And on that note, we'll bring the session to a close. Thank you all very, very much indeed. Thank you. Thank you. Thank you very much. We'll wrap it up. Cheers, guys and girls. Good night.